The case is now being live streamed. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attentions and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning to you all. I
morning.
hope that everybody can hear and see us okay. If you run into any technical difficulties, please let us know. We have some staff who's here and available to assist us with trying to correct and fix any glitches that we may encounter. My name is Justice Desmond. With me is Justice Ditkoff and Justice Singh will be your panel for this morning. Prior to our start today, the panel would like to take a moment to acknowledge the tragic loss of our Supreme Court Chief Justice Ralph Gants, who suddenly passed away on Monday. Chief Justice Gants was a great man and one who embodied all the traits that we wish we all possessed: fairness, empathy, intellect, and understanding. He was a brilliant man and a very kind person. He was a tireless advocate for racial equality and justice for all, and will surely be missed by all in the legal community. Our hearts and our prayers go out to his family and the many friends that he's made over his 40 years in both public and private service. I'd ask that you take a moment of silence for Chief Justice Gants before we begin our proceedings. Thank you so very much. With that, we'll begin our day's work. First case on our list today is 19P 0897, Commonwealth versus Jennifer Jorge and another. I understand, Attorney Milo and Attorney Renaud, that you'll be splitting your time 7.5 minutes each. Is that correct?
That's correct, Your Honor.
Yes, Your Honor.
Okay. And Attorney Renaud, will you be going first?
I will, Your Honor.
You have the floor.
Thank you, Your Honor. Suzanne Renaud for Jeffrey Marks. And I would just like to start by saying my sincerest condolences to the court about the passing of Chief Justice Gants. But we're here because Mr. Marks was the subject of an arrest warrant, actually a default warrant, and the police went into a third party's home and they seized matters that should have been suppressed. And I'm asking this court to reverse the lower court's judgment on this case. To begin with, Mr. Marks was the subject of a default warrant, which would be the equivalent of an arrest warrant. And in any case, if a person in his situation is in the home of a third party, Tatum has told us that he is entitled to a reasonable expectation of privacy. He's entitled to insist that the police have a reasonable belief that he is at that location prior to entering. And in this case, the police did not have that reasonable belief. They went to the property, they surrounded the property, they went into the curtilage, and they entered without having any belief that he was there. They had some indication that he knew a woman with a name of Jennifer George without knowing the spelling or where she was, but they didn't have any more information and they didn't conduct any additional investigation prior to entering. And in this case,
well, let me ask you this. Let me ask you this. Let me interrupt you for a moment. When they began to try to locate him, they went to was it his mother's house?
It was not specified specifically in the transcript if it was his mother's house or a relative. So there isn't even very much indication on the record about whose house they went to.
Okay, so it appeared that they went to his mother's house, and that his mother informed them that he was likely with Jennifer Jorge. And so then they ascertained what her address is, and they went there. That's not enough? You don't think that's reasonable belief?
Your Honor, a reasonable belief is not probable cause, but it's certainly not toothless either. And I think it's closer to probable cause than anything else. They didn't know the spelling of her name. They didn't know her address. They didn't have a particular indication on this record of how they verified it was her address. And it's not enough to say that he has some link to this woman. And again, we don't have very many details about how they made that link. They also have to ascertain that he is actually present. So even if there is some indication that he has a relationship with Jennifer George, in this case, they didn't make any attempt to ascertain that he was there. They didn't look for his car. They didn't look to see if he was someplace else. There was a lot of additional, so it's not enough to say that he has a link to this this address. They also have to say that he is there at the time. And if you compare this to the amount of proof that they used in Tatum to certify that that particular defendant was at that location at that time, you can see that this evidence falls short of that level. I don't believe the Commonwealth at any point has argued that they had a reasonable belief. The argument from the Commonwealth's point of view is that they obtained the information by asking the mother of Jennifer George about whether he was present.
My position is that all of this is ultimately irrelevant because they go to the property, they say, is he here? They said, yeah, he's here.
Yes, that's the Commonwealth's position.
Oh, lost him. Sorry.
So, Your Honor, I understand that their position is that they asked, and the position from Mr. Mark's point of view is that this is curtilage, and for the reasons stated in the brief. And when this particular officer, Officer Bates, went to the back door, he did not knock, consistent with his license. And so anything that happened from there, that was an illegal entry. And they exploited that
argument. It really, the crux of your argument is on the curtilage issue.
It's twofold. Yes, on the curtilage issue, threefold. I would say that there is a problem with the consent based on the facts. And then the third issue has to do with whether or not he was an overnight guest entitled to a search warrant and whether there were actual exigent circumstances that allowed them to exceed the scope of the purported consent to enter further into the home. So there are three different issues.
As to the curtilage issue, is it your position that that was properly raised through the proceedings below?
Yes, Your Honor. I know that this isn't the model
during the hearing.
I think that at the hearing itself, it is very clear that Mr. Malo brought forth photographs, evidence, and investigated this area. On top of which, the Commonwealth itself submitted evidence to support or disprove that this was curtilage. And the subsequent documents that were provided certainly raised the curtilage issue. As for the prior, I think the reason why I bring that up, if the Commonwealth was prepared to argue this at the hearing, it was clearly raised well enough in the prior motion papers, for the reasons I stated in the reply brief, that it isn't a very robust argument that was made in the initial motion papers, but it was sufficient for all the parties to know that the curtilage issue was going to be raised.
Sorry. The sign says deliveries to the back porch. They go to the back porch, people are knocking. What's the problem?
The problem, Your Honor, is I'm going to assume that you're saying that this is curtilage because deliveries go to the back porch. It's being used that way. The problem is that the knocking was on the front door. And
but when I get deliveries nowadays, sometimes they knock on the door, sometimes they call my cell phone. The point is they make some effort to tell me that they're there, which, what does it matter as long as someone's knocking? Why does it matter which door they're knocking at?
Well, it doesn't necessarily matter what door they're knocking at. What matters is that Officer Bates didn't have the right to be on that porch if he was not knocking. That is the part that matters because he was there. So when Mrs. George goes to open the door and there is a police officer there, he shouldn't have been there, period. So that entry that he engaged in, that was the illegal entry. And from there, everything flows that these are fruits.
Wasn't Mrs. George responding to the knocking? Isn't that what she says? That they were knocking very aggressively and she went to the door.
She says that she was responding to knocking, but again, Your Honor, that's the point, that it wasn't this particular officer who was knocking. He shouldn't have been on that porch. And again, this is a Commonwealth's burden to show that this was inevitable discovery. They had the opportunity to do that at the hearing. They did not do that. And you can't say it's inevitable discovery when the police officer shouldn't have been there. If Mrs. George had gone to that back porch, opened the door, and nobody was there, then we wouldn't be having the rest of this discussion. I'm almost out of time. There are many arguments in my brief, and I would like to rest on those unless you have additional questions. Thank you, Your
I think
Honors.
we understand. Thank you. Attorney Melosa.
Yes, thank you very much, Your Honor. May it please the court, Randy Milo on behalf of Jennifer George. Your Honor, to pick up where my sister counsel left off, getting past the curtilage issue, assuming that the court, which I agree with my sister that it is curtilage. They didn't know that Jennifer George was going to be there on that day. And all that they knew was that Mr. Marks allegedly, supposedly may be with Jennifer George, but they did not know that either of them would be there that day. But getting past that, Your Honors, looking at the consent, and Judge Callan focuses a lot of his opinion on whether or not Mary George gave consent to allow the officers into the home and to search. To begin with, when consent is the basis for a warrantless entry, it must be unfettered consent, and it must be something more than mere acquiescence to a claim of lawful authority. My argument to you, Your Honors, is that it was not. It was nothing more than mere acquiescence to a claim of lawful authority. If you look at the words of the officers, the actions of the officers, if you look at the actions of Mary George and the words that she testified to, it's fairly clear that she simply, as she said, I thought that they had a warrant, and so I let them in. But what we know,
Attorney Milo, didn't she inquire if they had a warrant?
She did not actually, and it was the officers who held up a piece of paper and said, "We are coming in," and they actually, part of her testimony, which Judge Callan left out of his brief, although he credits some of her testimony right in the same sentence, he leaves out the fact that she talks about that these officers told her that we are going to find out if he is here or else we are not leaving. So wait,
you don't say he left that out. That's fact finding. What he chose to credit, what he chose not to credit. Not simply that he missed something. We're not.
I'm sorry, Your Honor.
We're not to assume that he left something out or he missed something. His facts are his facts.
What I'm saying, Your Honor, is that when Judge Callan talks about Mary George allowing the officers in because they had a warrant, he takes that out of context. And he doesn't entirely include her entire statement, which is, again, part of why we're arguing that consent was not validly given. If you look at all of the facts, Mary George says that she does not have her glasses that day. She was never given a copy of the warrant. She was not allowed the opportunity to look at it or read it. There are, at this point now, multiple officers who are surrounding her on the back porch. They never told her that she could refuse to allow consent. They never told her that she could refuse to allow their entry. They actually begin by asking her, may we come inside? And whether you credit the officer's version, which is we asked to come inside so that we can talk about this quietly, or you credit Mary George's version, where she says that the officers asked to come inside because it was cold out. Regardless, the officers asked to come inside. They're allowed access.
She allowed that. She allowed that, right?
We are not disputing that she allowed that. She
right.
allowed them.
So there's consent there to enter the home. You agree with that?
I would agree that she allowed them to enter the home. The question of whether there was the question of whether the consent was valid, Your Honor. So I'm not disputing that she did consent to allow them in. It's the question of whether that consent was coerced and whether that was unfettered and freely given by Miss George. And when you look at all of the facts surrounding how and why she comes to allow them into, and again, she only allows them into the very entranceway by that back door. And when you come,
how is it possibly coerced if they say, may we come in because we're cold, and she says yes? How is that coercion?
Well, Your Honor, it's the totality of the circumstances. It's that she allows them into the hallway. She does not allow them into her home to search. Okay. And so if she allows them into the hallway, that is one thing. And again, we're not disputing that she did allow them into the hallway, but the reasons that she allowed them into the hallway, the officers then say, once they find out that he is there, and again, it's jumping beyond the point, okay? Once they find out that he is there, they then just push past her with 3 officers with guns drawn and start searching the home. And they should have never gotten to that point.
So is it your position that it was some type of conditional consent?
Again, I think the argument would be yes in part and no in part. And yes in part, again, she allows them into the hallway to have a conversation. She allows them out of the cold. She allows them to have a quiet conversation as the officers request. She does not give them the consent to go in and search the home. And that's the crux of our consent argument, is that, again, once they get into there, they should not have gone past the part where they were at.
How should this have played out? They're allowed to come into the home and they have an arrest warrant for him. And they've been told, he's here. He's here. We have an arrest warrant. And at that point, are you saying the homeowner can say, leave? Yeah, he's here, but we're not going to allow you to get him, even though you have an arrest warrant for him?
Your Honor, yes, Your Honor, that is in part our position. That the sanctity of a home is one that is held very near and dear. And the position is that the officers utilized improper tactics to first get into the home. And then once they get there, they have the home surrounded. There's no exigency. They could have very easily continued to secure the premises and gone and gotten a search warrant to go in and actually get Mr. Marks. It all comes down to, Your Honor, whether a reasonable person will believe that the officers properly obtained consent from Mary George, and we will ask Your Honors to consider that they did not. The last piece of my argument, Your Honors, as I'm running out of time, deals with the Miranda warnings, and I will simply say that, again, while it's not a true to form interrogation, they have both Mary George and Jennifer George in handcuffs. They make the statement that they're in your house, the drugs, you're all being arrested, and that is enough to meet the requirements of Miranda, and Miranda should have been given. And that statement alone
but there was an interrogation. Are you saying there was an interrogation?
I am saying that using that statement, utilizing that tactic was the functional equivalent of interrogation. And thank you for your time.
One final question. You say that they could have continued to secure the home. Does that suggest that you have no quarrel with the fact that they secured the home?
I'm sorry, Your Honor. You were somewhat broken up. I cannot hear that question.
You were saying that they could have continued to secure the home while they went and got a search warrant. So does that infer that you have no quarrel with the fact that they secured the home?
No, Your Honor. What I meant by that was that they could have continued with their officer presence outside of the home and surrounding the home to ensure that there was no means for which anybody can escape. And that at that point, they then should have gone and gotten a search warrant.
Thank you very much. I think we get it, Attorney Milo. Thank you.
Thank you, Your Honors.
88 Lynch, what do you say, sir?
Good morning. May it please the court. So I just wanted to acknowledge I noticed in the reply brief filed by Marks that she did properly, I believe, point out that I perhaps made a mistake on the facts as to whether the judge made a specific fact finding as to whether the police knocked on the back door. But, you know, I think Justice Ditkoff put it earlier, like, does it really matter what door they were knocking on? Also, I think someone observed earlier that Mary George herself testified that she heard knocking from the back door. So I don't really think that there's a reason to say that the police weren't knocking on the back door. But in any event, I think that the Commonwealth's position in this case is that the police have reasonable belief that Marks is inside of the third-party residence indisputably at the time when they learned from other people in the side of the house that he is there. And with the arrest warrant in hand and reasonable belief that he is present, they didn't need anything else in order to go to the front bedroom where Marks was located. And I mean, really, if he were in his own house and they learned that from other people inside of the house that he was there, they could just go in without any additional justification. The Commonwealth has also raised a variety of procedural threshold questions as well.
What do you think home of a third party for Stiegel versus U.S. purposes means? I mean, is it enough to make it not a home of a third party if it's a place that you regularly stay? It's your mother's house that you often stay, overnight guest. How much connection do you have to a place before it's no longer a place of a third party?
I'm not really sure if that's ever really been made clear by the case law. That's a good question. It seemed, I mean, I think Peyton is a case where the subject of the arrest warrant was arrested in his own home, and it was not disputed that it was on his own home. And then Stiegel is then a case where the person who is seeking to suppress the drugs was the homeowner, not the subject of the arrest warrant. It seems like it's homeowner. That seems to be what it comes down to. And then when you look at cases like Minnesota v. Olson, that's the so-called overnight guest case. But I think that all that Olson stands for is that where you're an overnight guest, you have as much protection as if you were in your own home. But I don't think the case law makes it clear exactly how much of a connection you need in order to go from the house being a third-party residence to being your own home. But as to Marks, it doesn't really matter, because even if it were his own home, he doesn't get to insist on a search warrant. And it also doesn't really make any sense for him. I mean, it doesn't make sense for him to have more protection in someone else's home than in his own. So I don't think it's really, I'm not really sure if, oh, I'm sorry.
No, go ahead, finish your answer.
No, I was done answering. Unless Justice Ditkoff has anything more on that.
I don't know the answer either. It's interesting.
It is very interesting, but I mean, ultimately, I don't think really any of this matters, because even if you were to say that Marks is an overnight guest, they have reasonable belief, and they lawfully learned that he is in there from the people inside the house. And the police were allowed to go on the porch. They were allowed to go there in order to speak with, let's assume that it's curtilage. They were allowed to go there for the purpose of speaking with the people inside of the house. And that's ultimately what they did. So there's no problem with them learning that Marks is there.
Could you address the issue of even when the police are there and are trying to apprehend him, the business about the further entry into the living room?
Oh, to go retrieve the shoes?
Yeah.
Well, at that point, they were acting on his request to go get his shoes, and then they happened to stumble upon the drugs that are in plain view on the coffee table. So I don't
really a request, please get my shoes for me? Wasn't it simply my shoes are in the living room?
I think it was, may I have my shoes? Where are they? They're in the living room. And so they go there to get the shoes because they don't want him to walk outside without shoes, because they're trying to be decent. I would infer from the circumstances. Also, I don't see why Marks has any reason to complain about them walking around inside of the house, because again, he's not, I mean, again, at best, he's a overnight guest, and that still doesn't get him a search warrant. So.
But the other party, right?
Well, I'm sorry, you mean George. But George, I don't think that she owns up to living here either. I don't think she's a resident of this place either. The only person who might be able to complain about all of this is Mary George, but of course she's not filing a motion to suppress. That would be, yes.
The judge did find that he asked for his shoes, but I didn't actually see that in the transcript. Maybe I'm missing it. I hear the officer asking Mr. Marks where his shoes are, and then telling someone to go get them. Am I missing it? Is it somewhere in the transcript?
That's a good point. I apologize. I don't have that quite ready to hand. I don't think it's been claimed that that's a clearly erroneous fact finding. Also, I don't think anything really matters. I don't think anything turns on whether Marks is asking for them to go get his shoes or not, because I don't think he gets to complain about them walking around inside of the house. So I don't think it really, so I apologize. I don't have that record site ready to hand. I didn't think that was being challenged. And so as to the statement, the suppression of statements as to George, I think it's pretty clear that arresting your mother in front of you doesn't call for you to incriminate yourself. Clearly, there's no actual interrogation, as Justice Singh pointed out earlier, and it's not the functional equivalent of interrogation to arrest a family member, because that doesn't call for you to incriminate yourself. Even where the defendant himself is being arrested, if he's spontaneously saying an incriminating statement, in Brown, for example, was held, that's not arresting the defendant, is not the functional equivalent of custodial interrogation, or not of interrogation. So I don't see how arresting Mary George in front of defendant George is interrogation of defendant George. And with the proviso that I made a mistake in the brief, I would be happy to rest on my brief unless there are any more questions.
One final question, at least for me, can the officers use a ruse to get consent to get into the house?
I don't know of a case that says that you can't use a ruse to get consent, because I don't think that that's coercive. I'm not aware of any authority that says that. And I don't think that that's what's being argued here. I think what's being argued here is that I think what's being argued really by George is that they didn't really show her the warrant.
Certainly you'd agree there are certainly rouses that would be coercive, like, your gas is about to explode, let us in.
Well, maybe that could be cool. I mean, maybe. I mean, I don't think that I don't think saying maybe in some other case, that would be interesting, but I don't think that's what happened here, because all they said was, we have this arrest warrant, can we show it to you? And that's not coercive. And unless there are any more questions.
I think we understand the arguments. Thank you all.
Thank you.
Stand submitted.
Thank you, Your Honors.
The case is now being live streamed.
Attorney Gaffney.
Thank you, Your Honors. Good morning, Your Honors. My name is Edward Gaffney, and I represent the defendant, Angelo TEIXEIRA. Mr. TEIXEIRA is appealing today his conviction of possession of ammunition, possession of a firearm, and possession of a loaded firearm. At the outset, I'd like to focus I raised a handful of issues in the brief. I'd like to focus on a couple of them this morning. The first is the argument that the possession of ammunition conviction should be reversed because the jury may have rested its conviction on evidence that cannot support a guilty verdict. And I say that because as the court knows, the defendant was was the Commonwealth's theory of the case was that the defendant had a loaded 9mm Sky handgun loaded with a magazine containing 10 bullets that were marked FC, and he also had on his person a spare magazine, which also had 10 9mm bullets marked FC inside of it. And although the defendant was originally charged with 2 counts, and the Commonwealth dismissed the count that was based on the bullets inside the magazine in the gun, the jury never knew that. The jury only knew he was charged with 1 count, and according to the language in the indictment, the ammunition at issue were 10 9mm Luger cartridges marked FC contained within a magazine.
One's got a gun, and he's got 2 magazines for that gun, and one's in it right now, and one's not. Why is that cache of ammunition disparate enough that it's like 2 different drug deals? Why can't you just charge all those ammo, which is for the gun, as 1 count?
Well, I think it's because under, in this circumstance, Your Honor, it had to do with the circumstances of this case, because the spare, what I call the spare magazine, the one that was not in the gun, there was no evidence, there was only indirect circumstantial evidence that the defendant possessed that as a result of that long series of, well, he had it, he passed it off to a friend, a second put it in a garbage bag, the second friend took it in the garbage bag and put it in the driveway. In other words, there was direct evidence, if the jury credited it, which I certainly do not concede, but the jury could have credited, and there was eyewitness testimony of the defendant shooting a gun, and there was the fingerprint of the defendant's on the magazine inside the gun. So there was direct evidence with respect to the ammunition contained in the magazine in the gun, but there was no direct evidence that the defendant was in possession of the spare magazine. That had to come about as a result of this series of inferences. And so I would argue that under those circumstances, I mean, this was the jury's, I mean, this was the Commonwealth's choice. I suppose theoretically they could have done that, but under these circumstances, they chose to make 2 separate indictments, and in fact dismissed one, making clear that the only ammunition that they were going forward with. And I just thought of one other reason, Your Honor. I'm sorry about that. The second reason is because they were going forward on a charge of possession of a loaded firearm, and if you're going to do that and you convict of ammunition based on the ammunition inside the firearm, that's a lesser included offense. So they were going with these 2 separate ways, because if they convicted him of the possession of ammunition on the spare magazine, they could get an additional sentence, an additional conviction.
Any chance you've seen the recovered cartridges, the expended ones?
I'm sorry, did I see the?
My question is, are they marked FC?
Yes.
The expended ones?
Yes.
So the fact that referring to it as a spare cartridge seems awfully telling, but aren't you still arguing the weight of the evidence? The government made out its case. They argued in closing specifically what ammunition they were referring to. The judge instructed specifically what ammunition they were referring to. They had a link between the video and the direct evidence. Why is that not enough, Attorney Gaffney?
Actually, I disagree, Your Honor. I don't think that the judge did instruct the jury in this case. What she did was she repeated the language contained in the indictment. That's all. She didn't talk about a spare magazine. She said that the defendant is charged with possession of ammunition, and then she went on to repeat the language in the indictment, which was this ammunition was 10 9mm cartridges marked FC contained within in a magazine. That language was precisely described the bullets inside the spare magazine, but it also precisely described the bullets in the magazine in the gun. In other words, there is absolutely no way that we can know whether the jury convicted the defendant of this charge based on the bullets in the magazine in the gun or the bullets in the spare magazine, because and the jury, by the way, was never told that they could only convict the defendant of this offense based on the bullets in the spare magazine, and they were never told that they could not convict the defendant based on the bullets contained in the magazine in the gun. And
But there were no bullets contained in the magazine in the gun because they were expended.
Oh, but the defendant, the theory of the case here from the Commonwealth's point of view was that the defendant had the gun when it was loaded, and he fired it, so that he would. So theoretically, if the jury credited that evidence, he was in possession of the ammunition inside the gun.
Hence the loaded firearm.
Exactly. Which, by the way, is why I believe it's not just possible, but I think it's likely that the jury convicted the defendant of possession of ammunition based on the ammunition inside the weapon, because they found him guilty of possession of a loaded firearm, and they were never told, if you do that, you can't convict him of possession of firearm. I'm sorry, you can't convict him of possession of ammunition. So that's my argument with respect to the ammunition piece. Now, I also have a similar, I believe a similar level of confusion arose with respect to the firearms charge, because there, when the second gun was introduced into evidence, the Taurus, which was the gun found in the driveway, wrapped in the sweatshirt, next to the Sky handgun. The Sky handgun was the one that was used in the gunfight, and the Sky handgun was the one with the defaced serial number. The Taurus was found with the Sky handgun. There was no evidence that the defendant owned it. There was no evidence that he possessed it. There was no evidence that he even knew it existed. And yet, over objection, the Taurus was allowed into evidence as an exhibit. And the bullets inside the Taurus were also allowed into evidence as exhibits. And I believe that in the context of this case, was a reversible error. And the reason I say that is because we know from the judge's own words that the introduction of this second gun was confusing. She said so on two occasions. Once in the charge conference, when she was discussing with the lawyers which exhibits should go into the jury room during deliberation and in what order. And she said,
in what way?
In what way was it confusing?
What would they be confused about?
Which gun the defendant was charged with.
Well, the judge instructs that it's the gun the Commonwealth alleges Mr. TEIXEIRA possessed is the SCCY model CPX2 9mm Luger.
Exactly.
Doesn't that solve the confusion?
No. And the reason I say that is because the judge told us herself it doesn't solve the confusion. Because at the beginning of the,
after she gave that instruction, she said, my instruction doesn't solve the confusion?
No, before the instructions. When at the beginning of the at the beginning of the last day of the trial, before the final instructions were given, the judge said, the defendant's attorney specifically asked the judge to instruct the jury that the defendant was only charged with one gun, basically re-upping the objection to the presence of this second gun. And the judge said, she was concerned about this, and she acknowledged his concern, and she said, so I think as long as counsel argues clearly about that, I don't think there's going to be any confusion. I agree with you, there would have been, but for specifically listing it in my charge and also specifically listing it on the verdict slip. And the problem was it wasn't listed specifically on the verdict slip. And so although the judge did instruct in her final instructions what the defendant was charged with, the jury was never given any limiting instruction with respect to the Taurus. In fact, they were told, consider the evidence as a whole. Don't make up your minds until you've discussed all the evidence and all the facts and inferences from whether the defendant possessed the Taurus, or actually whether the defendant was guilty of possession. And this evidence, remember, included testimony as to whether the definition of a community gun, which is a gun placed in an area that's easily accessible to a group of people so they can avoid prosecution for unlawfully carrying a firearm. And that confusion, Your Honor, also existed, and we know it existed because the jury's first question after beginning deliberations was for a definition of joint possession and possession. What in the world were they worried about deciding what is joint possession in a case where the Commonwealth's theory was the guy had the gun in his hand and the spare magazine in his hand? That's my possession case, says the ADA. And the jury wants to know about the definition of joint possession. And I would argue it's because they're considering whether the defendant is guilty of possession of the Taurus. And the reason I say that is because there was evidence, not only, by the way, not only of this joint possession community gun testimony, but the Commonwealth's expert, their ballistics.
Let me ask you this. Why does the admission of the gun cause the problem as opposed to the description of the Taurus?
Well, for a few reasons. Because the admission of the gun puts two guns into the jury's hands. And remember, it's not just the hand, it's not just the, it's now we've got a gun without, by the way, a gun with an intact serial number. The jury, by the way, found the defendant guilty, not guilty of possession of a firearm with a defaced serial number. That was the Scott. The gun that they charged him with had a defaced serial number. The gun that they didn't charge him with was intact, and they found him not guilty of possession of a gun with a defaced serial number. And by the way, Your Honor, the Commonwealth went out of its way to elicit testimony from its ballistics expert that the Taurus, they test fired the Taurus. They told the jury that under the statute, this classified as a firearm. And he inspected the bullets and said that classified as ammunition under the statute. So it's entirely possible. Remember, the jury they were told what the Commonwealth's theory of the case was, and the judge did instruct as to, or she did say what they charged him with, but they never were told that they couldn't reject the Commonwealth's theory of the case and decide, you know what? We have the elements of the crime. We think they got it wrong. We think that he's guilty of possession on a joint possession theory of this other gun, the gun with an intact serial number. And that explains these otherwise fairly inconsistent verdicts. I mean, if they went with the Commonwealth's theory of the case, why was he not guilty of attempted assault and battery by means of discharging a firearm? And why was he not guilty of possession of a gun with a defaced serial number? That's inconsistent unless you are open to the possibility that because there was confusion, as the judge acknowledged, and because there was no limiting instruction with respect to the Taurus, and because we had this other evidence of the fact that that there was a community gun and joint possession, and the jury's considering joint possession, all of these things in my mind come together to make it a real possibility that the jury was thoroughly confused about what they had the power to do and what they didn't. And
before your time runs out, do you have any way you can tell me that you could do an ABDW with a pellet gun and an offensive touching theory?
Yes. It's the, I think of offensive touching as, the two standard examples are spitting and tickling. Imagine, if you will, a pellet gun, and someone had a gun, the perpetrator, and brought it to the back of your neck and just sort of like moved it along your neck in this kind of obnoxious, offensive way, but it absolutely did not hurt you.
Then how is it being used as a dangerous weapon if you're doing that? It's got to be used as a dangerous weapon. It's not dangerous per se.
Well, sure it is. It's a dangerous weapon. It's a loaded pellet gun.
Do you have a case for that?
Well, I think that the cases that describe whether or not the cases that address whether or not and I'm sorry, I don't have a case off the top of my head, but what I'm thinking, Your Honor, is that the cases that speak to whether a particular thing is a dangerous weapon or not, and how we determine that is how it's used, the ground or a table or something like that. It's in those cases where we've got something that isn't a gun or a pellet gun or a knife. Those are dangerous weapons. That's it. In fact, I think that there are some instructions, some model instructions that in fact go to that point. They say, I'm instructing you a knife is a dangerous weapon, or a loaded firearm is a dangerous weapon.
Well, yeah, there definitely are, but for a pellet gun?
Well, I don't think it exists for a pellet gun in the model instructions, but a gun, a pellet gun, a BB gun, a knife, there are a mace. There are lots of weapons that don't get listed in the model instructions. I think that qualifies without having to, decide whether it's being used as a dangerous weapon to in fact be. You can be guilty of assault and battery by means of a dangerous weapon if it's a pellet gun, if it's a handgun, if it's a 38, and you obnoxiously draw it along somebody's ear or neck or hairline or something. I think that's an offensive touching.
What if you use the loaded firearm to, put it in somebody's back to move them along?
Well, it depends, and yes. I mean, you're probably guilty of other offenses as well, but that would be, if you're going to say, if you're going to be going with a theory of assault and battery by means of a dangerous weapon, yes, that's an assault and battery by means of a dangerous weapon. That is not necessarily harmful or painful. If you just poke somebody gently with the gun, I'm sure you're guilty of threats as well as a lot of other things, but that's. Yes, I agree with Your Honor. And I would just close by saying, as I see my time is over, I apologize for that, but I would just close by saying that because the introduction of the Taurus as an exhibit in this case, the jury had a full picture. They didn't need a full picture. This was objected to, and therefore the court's review is under the prejudice standard. And under the prejudice standard, the court should reverse unless they're sure that there was no effect or but a slight effect. And I think that is absolutely impossible.
Thank you, Attorney Gaffney. I think we got it.
Thank you, Your Honor.
Thank you. ADA Lewis, what do you say with respect to they found him guilty of the loaded firearm, but not guilty of the firearm that was defaced?
I think that we can't get it. First of all, good morning, Your Honors, ADA Lewis on behalf of the Commonwealth. I think that we can't get into the jury's deliberations on why they might have found the defendant guilty of one conviction, of one charge versus the other. I think that it's the defendant's claim regarding what he says is an unknowable basis for the possession of ammunition verdict is speculative at best. And I would point to three reasons. First, the indictments themselves. Second, and perhaps most importantly, the way the evidence came in and the way the prosecutor argued that evidence. And third, the judge's instructions to the jury on a few occasions. And what I'd like to begin with is what the judge told the prospective jurors was the allegation here. And quote, the judge said on three occasions when speaking to the prospective jurors, of whom some were ultimately sat on the jury, the judge said, the Commonwealth alleges that Mr. Teixeira possessed a firearm. The Commonwealth alleges the firearm had a defaced serial number. The Commonwealth also alleges that Mr. Teixeira possessed a separate amount of ammunition. I think that needs to be taken together with the indictments themselves, saying first, the possession of ammunition indictment, as my brother said, charged the defendant with unlawfully possessing ammunition, to wit, the 10 9mm Luger cartridge casings marked FC contained. Go ahead, Justice Ditkoff.
Where are you in the transcripts?
So what I just quoted as the judge speaking to the prospective jurors, it's on 3 occasions during the impanelment. That's at volume 1, page 45, volume 2, page 12, and volume 3, page 10.
Thank you.
I'm now moving. Oh, go ahead.
Doesn't that same argument cut against you, though, when we talk about the defaced firearm?
Your Honor, I hadn't admittedly hadn't considered that. I don't think so, because I think the issue the defendant's raising here is that you have this possession of ammunition charge and the carrying a loaded firearm charge. From what I understand, the defendant is arguing is that the jury was never told not to consider the evidence that was fired from the loaded firearm when considering the possession of ammunition charge. And my response to that would be that.
Well, I think he's also arguing. Let me interrupt you for a moment, because I think he's also arguing that the introduction of the other firearm, which was not defaced, confused the jury. And so how do we know that they didn't hook him on the firearm that was not defaced, because it was introduced into evidence and it shouldn't have been? So goes his argument, I think.
I understand that question. And I think that, again, I would point to the judge's instructions and also the prosecutor's closing argument with respect to the Taurus firearm that was not defaced. And I would say that the prosecutor in her closing argument, and I can point to various places that are also quoted in my brief, make clear that that Taurus firearm was attributed only to Harris and not the defendant. That's first. And second, the judge in her instructions making clear by quoting the indictment that the defendant was only charged with the SCCY firearm. And we assume, the defendant's argument assumes that the jury ignored those instructions. And the case law is clear that or this court assumes that the jury does follow the judge's instructions. And again, those instructions were clear. The fact that the judge during sidebar or other conversations with the lawyers and the attorneys talking about perhaps that this was confusing is not at issue here, where we have these clear instructions to the contrary. And go ahead, Justice Desmond.
My only pushback was they found him not guilty for the defaced firearm that the judge made clear is the one he's being charged with.
And oftentimes there is jury nullification and a splitting of the verdict, and I think that's what could have perhaps. I don't think it has. This court could. I think it's entirely speculative to speculate. It is speculative that the jury was confused, and that's what resulted in these verdicts here. Specifically, where you look at the prosecutor's closing and how clear 2 things were in that closing. One, the difference between this spare magazine and the carrying a loaded firearm, those 2 charges, and also that the defendant was only being charged with the SCCY firearm. And the reason, I think, I'll finish that thought, only being charged with the SCCY firearm, and then also the judge's instructions to that point. But what I was going to say is, I think it's important to step back and look at the relevance of this Taurus firearm and why it was admitted. And it was directly, as the judge found, and I'm quoting her on volume 5, page 132, she says, "I think the fact that they're both found together is enough to make it relevant," meaning the Taurus firearm along with the SCCY firearm. And I think it's important to point out that the admission of this firearm, the Taurus firearm, was relevant to corroborate the video evidence, which showed, as the Commonwealth alleged, the defendant's friends helping to stash the SCCY firearm and the loaded magazine in the driveway of 11 Wendover Street. So the fact that these are found together corroborates the Commonwealth's theory of the case of his friends helping take these 2 items from him and stash them in that driveway. I think bringing it back to the evidence is important here.
So is there any indication that the indictments were attached to the verdict slips?
There's not, Justice Ditkoff, and they were read. I have not found an indication in the record that they were attached. The judge did instruct the indictments aren't evidence. So to the extent that that means they went back to the jury during deliberations, perhaps it does, but the indictments were read clearly by the clerk at the beginning of the case, and also effectively quoted by the judge in her instructions to the jury on each charge. And go ahead.
Is your brother correct that the expended cartridges are also marked FC?
I think he is. I actually just recently looked. I looked back at the transcript, and I didn't write down. I know it's volume 5 where the ballistics expert testifies, but I do think there's an indication that there was evidence that the cartridges were marked FC. If I'm incorrect on that, I will certainly follow up with the court. But I agree on that point. If the court has no further questions on the basis for the convictions, and then also the relevance of the Taurus, I would just like to, regarding the ACC, I would just like to point this court to an unpublished opinion that where a panel of this court found a pellet gun to be dangerous as used, and in a footnote said it wasn't reaching whether it was dangerous per se, but was finding that it was dangerous as used, and that's Commonwealth versus Desmond D, 2011, Mass App, unpublished, Lexus 1265.
You have the docket number?
Your Honor, I do not have a docket number. I'm happy to follow up with a 16L on that. But I just, in looking further at this issue, I did find that one unpublished case where again, a panel of this court discussed a pellet gun. The dangerous weapon at issue in that case was a pellet gun, and the court had found it to be dangerous as used. But I think what's controlling on the ACC issue here is Commonwealth versus Widener, where this court did find that the modified categorical approach was not applicable to ABDW, and instead it was specifically found that it's a violent crime. That is, ABDW is a violent crime within the meaning of Chapter 140, Section 121, without regard to whether the underlying conduct was intentional or reckless. And I think that's controlling here. I am happy to address any of the other issues raised by my brother.
I'd like to hear about the jury waiver.
And sure, Your Honor. So the jury waiver here, I would say, sufficed to show that the defendant had voluntarily and intelligently waived his right to a jury trial on the enhancement portion of the case. I would point to a few points. First, there was a jury waiver form. That form, together with the colloquy itself, showed that the defendant agreed to waive his right to have a jury decide the case. I would say that the defendant understood the nature of a jury trial, namely that the jury decides the facts of the case based on the trial on the underlying charges. And I think it's important to think about what had preceded the enhancement portion of the case here. I would acknowledge that during the colloquy, the judge could have said more explicitly that at a bench trial, as opposed to a jury trial, it is the judge who would be deciding the facts and the law. But I think this was implicit in what she was saying, and the defendant understood this. And I think, again, you need to look at the fact that he had just sat through this jury trial, understood that a jury decides the facts of a case, and is now agreeing to a bench trial where the judge would decide the facts and the law. So I think, again, the record needs to be looked at as a whole there. In terms of any question of whether he was pressured or cajoled, I think it's also important to look at the fact that he is communicating with the same attorney he had his previous trial. Originally, the attorney and the defendant said we would like to have the same jury at the enhancement portion of the trial. then at the end of the first phase of the trial say they indicate they'll go jury waived. And even after the colloquy, the defendant asks to consult with his attorney. The judge gives him an opportunity to do so. They then come back and move forward. So this communication with this attorney over a 2-phase trial, I would say cuts against any argument about being pressured or cajoled or an inability to rationally waive his right to a jury trial. If you have any more specific questions on the colloquy, I'm happy to answer them.
Hearing none, we'll consider the matter submitted.
Thank you, Your Honors. I just wanted, may I just make one point? I didn't have a chance to acknowledge the fact that the trial prosecutor in this case, Caitlin Fitzgerald, if she wasn't stuck in 815 in Superior Court, she did watch this argument over the court's live stream. I wanted to acknowledge her presence. So I'm sorry to interrupt you, Justice Desmond, but I wanted to make sure that I said that. Thank you for your time, Honors, and I'll rest on my brief.
Thank you kindly. The matter stands.
And up to 8 consecutive life sentences prior to trial. Now, having been sentenced under the law, the most he's facing if he were released today is another 8.5 years in prison followed by probation. So he returned. And in fact, the trial judge found that his risk of flight is not high. And in fact, not a risk to the complainant or the complainant's family. And the DOC has classified him as low risk. Where the rubber meets the road here is the trial judge's finding that no conditions can assure, quote unquote, no danger to the public given the quote unquote nature of the offense. So, but in sentencing, the trial judge imposed the mandatory minimum followed by probation with conditions that are mimicking those that we're requesting here. And in fact, if those conditions were sufficient to ensure the public's safety 8.5 years from now, then they're certainly sufficient to ensure the public's safety now. So,
well, hold on. I'm gonna ask you about that because next to nothing, perhaps those conditions are helpful. I mean, what is the judge to do? I mean, he only has but so much sentence he can impose, and so if he imposes 8.5 years. With some conditions, then that arguably is better than no conditions. And so in this case, the judge basically said, this is a person who's very cunning. And because of that, we may be able to use these conditions to identify him after the fact, or perhaps in the middle of the act, but it won't prevent the act. And so why would that be an abuse of discretion?
So well, it's an abuse of discretion, and I want to address factually your answer, but your question. But I also have an answer that's legal that goes to his application of the standard here. So I'm going to do the factual part first, and then I'm going to go to the standard of review. So the factual part is that this was a physical offense, not a computer offense. And so if he is confined to home or GPS, he's not going to be able to commit a physical offense. There's no electronic offense here. There's no child pornography, naked selfies, things like that. And in fact,
wasn't a lot of the grooming taking place via text and email messages?
Well, sure, that's the Commonwealth's evidence, and that's true. But given those conditions that I just recited, he's not going to do that. But even if he did that, again, there's no opportunity for him to commit the offense because it is a physical offense that we're talking about. But I also want to move on to the standard of review that because the judge was clearly struggling. He clearly saw that this guy is a low risk guy. And so he was struggling with the standard of no danger. And so he applied an incorrect security prong standard of no danger. That's not the standard. It's a standard that comes from Springfield Railway Terminal, which is a case against a corporation. But that case in turn comes from an SJC case called Senior. which employed the language "no danger," but in Senior, that language was dicta. The defendant had prevailed in getting a stay, and the judge that granted the stay said, this guy is no danger. So there was no reason to fight about it in Senior. Senior relied on Hodge and Allen, and if you look at the pin sites from Hodge and Allen that Senior cites to, they absolutely don't say no danger. It's the balancing test that all judges employ when they're setting bail. And since Senior, I think it was more important, the SJC has reiterated the standard. It's not no danger, it's much more general. This is a quote from Christie. The judges are to consider in the ordinary circumstance, quote, the danger to other persons in the community arising from the defendant's risk of reoffense. That's in Christie, but it's also in Mateer, it's also in Charles. So the application of an, yes, Your Honor.
Well, wasn't that, in essence, wasn't that what he was trying to articulate? Or you quarrel with that's what he was trying to say?
I'm not sure I'm completely understanding the question, but I think what I'm saying is the judge he makes clear in his written findings that he applied a standard of no danger, where the difference between no danger and some small risk is quite significant here, because the defendant, nobody is no danger, right? Just empirically, but it's clear this defendant track record, he's, no criminal record prior to this case, 3.5 years on bail, no problem. He is a low risk. The judge was struggling with this standard that he applied incorrectly. So no risk of flight, no risk to the complaining witness, and really only a risk to the community, a generalized hypothetical one. So that the Hodge-Christie standard doesn't really quantify the acceptable risk. It's expected that judges will balance, not no danger, and it's an absolute bright line test. It's balancing the risk against the merits of the appeal. And so this sort of leads me into the second part of the case. It's just that inherent in that balancing is the liberty interest that's implicit in the merits of the appeal. And here the merits are quite strong. He has a jury selection claim that's structural error, the disallowance of defense peremptory. The judge made a clear legal error saying that there's discrimination against minorities generally, when the SJC in Ortega and the First Circuit in Gray versus Brady has said that's not cognizable. It has to be a specific.
What do you make of Lopez, where trial judges are strongly encouraged to skip the first step of Suarez and jump right into the genuineness and adequacy of a reason?
So that case, are you talking about Lopez or Sanchez?
I thought it was Lopez, 479 Mass.
Okay, there are a number. What's
the new one?
My understanding of those cases is that they arise in the posture of a prosecution challenge, particularly in a case where a defendant is concerned because somebody who shares a racial identity with him is being excluded. That's only a plus factor. It's not a requirement. We know that from Powers. But what that is saying is skip that and go right to it to protect the defendant. That's not what's happening here. This is a defense peremptory being disallowed. And so I don't think the SJC has ever said skip the first step of bats and sores in order to protect the government. It's always been a concern about protecting a defendant's right to a fair trial, and Sores actually says a fair cross section as well. So there's that. I mean, there are some interesting legal debates that we can get into in that case. The Hodge-Christie articulation is just a quote, an issue which is worthy of presentation to an appellate court, one which offers some reasonable possibility of a successful decision on appeal. This is far beyond that. Now, also Mr. KOZUBAL was convicted of being a mandated reporter. indecent A and B on a child. That is the instruction here. It's not really given to oral argument, but I think I can sum it up quickly, which is that the judge gave an instruction of who is a mandated reporter, which is an element of the offense and greatly aggravates the sentence. And the instruction massively expanded the definition of who is subject to a penalty under this statute. What was really at issue in this case is teacher or any other person paid to work with children. But what the judge did, the trial judge did, and which it appears that Justice Sachs agreed with us, is that the judge improperly excised a modifying clause about any other person paid. It's any other person paid, any other person paid who works in certain state-funded programs. Now, I'm oversimplifying, but that is essentially the argument. And again, as the new statute hasn't been interpreted before, again, that clearly fits the merits prong.
Counsel, not to take you off your
Yep.
group, but what do we do with 20P 601? I mean, there are three of our colleagues that one security factor, even with the special COVID generousness. Why isn't that binding on us?
It's not binding on you, Your Honor, for a number of reasons. Those were really a different animal. Those Christie COVID stays were set up under a special procedure never before seen in this court. They were decided with lightning speed. In this case, the Christie stay went from trial judge decision to panel decision in 2 months, April 8th to June 8th. Here, we're arguing 14 months away from the trial judge's decision on the stay. And we still haven't had a decision. We were still carefully considering it. The court has had, 6 months to review the record and the briefing in this case. The prior panel decision was a 128. It wasn't reviewed by the other members of the court. It was based on no oral argument, and more importantly, under the rule, no briefing. Obviously no FAR. It's essentially interlocutory. They were necessarily decided in a hurry. They're just different animals, and they should be considered separately. And I would also point out that there's actually 2 cases pending that were argued, I think, last week in the SJC, Elbert and Nash, which have to do with whether single justices have been applying Christie incorrectly, in the sense that they're viewing it as a separate prong that the defendant has to satisfy, rather than an additional reason why he might or she might be released. And so that's another reason why I would caution against reading too much into that. But as I said, those were decided with lightning speed, unlike anything this court has ever done before. This is a much more careful and considered approach. I've been fighting for a stay for Mr. KOZUBAL since October. And so I think this is by far the higher quality of the 2 presentations to the court. So unless the court has further questions, I'm happy to rest on my briefing.
Thank you, Attorney Nathanson. Hearing none, we'll take you up on your offer.
Good morning, Your Honors. Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth is asking this court to find that the single justice did not abuse his discretion or commit an error of law when he denied the motion for a stay in this court. Your Honor, as counsel points out, it's been 14 months since the trial. Had this matter been stayed, the Commonwealth would likely be moving to revoke the stay under Mass Rule of Appellate Procedure 6B4 for failure to proceed with the appeal. But regardless, Your Honors, the single justice did not abuse his discretion when he denied the motion to stay. The single justice found a different issue worthy of presentation on appeal. The single justice identified the issue of the jury instruction regarding mandated reporter. I suggest that that is unlikely to prevail on appeal, but even if it did, that would be a sentencing enhancement. The defendant is subject to a mandatory minimum penalty based on that aspect of the instruction. So even if the defendant did succeed in prevailed on that case on appeal, he would nevertheless still be convicted of the lesser offense, and as the trial judge had said, would still be facing a committed sentence.
If
Your Honor,
we're satisfied with the assessment on security, need we reach the merit argument?
no, Your Honor. The defendant, if this court is satisfied on security, the court need not reach the merit argument. But if the court were to reach it, I suggest that the court would not be granting relief based on the merit claim.
And just on the merit claim, it's some chance of success, not probable chance of success. Is that correct?
Yes, Your Honor. It's something worthy of presentation to a court on appeal. I suggest it's something that's not frivolous. And certainly there's many issues that are raised in many different appeals, and I suggest most of them aren't frivolous, but not all of them and not even most of them prevail on appeal. So here I suggest we're only looking at the security issue.
So could you address your brother's argument that if he's got these conditions in place, what is the real risk given the circumstances of this particular case?
Here, the trial judge who saw the evidence, who heard the testimony, who saw the text messages that came in, found that this defendant was a predatory person. And this defendant managed to befriend the victim and her parents when they were attending a community education class, and committed offenses right under the noses of interested adults, and committed the grooming of the victim by text message electronically. Here, the defendant, if he were released, again, would have access to devices, to internet, to other types of things, and again, might be able to groom somebody by that means, and again, might arrange some sort of a physical encounter. Just in order to stay home, there's no guarantee that there would be complete compliance with that. And again, the trial judge did find the security risk, and the single justice, it appears he deferred to that, but however he reached that conclusion also found it.
Well, should we be concerned about that, whether there was a deference to the judge or an independent determination?
Your Honors, I think either way you look at it, it comes out the same. The more I read Justice Sachs's statement in the docket, it did seem that he may have been deferring primarily to the judge on the security issue. And again, that would be, I would suggest, a sensible way to proceed, because the trial judge was there for the trial and did see the evidence in greater detail than a single justice could see it.
Attorney Cusick, what do you say with respect to the standard? Your brother says that the language where the trial judge said that there was no danger was inapt.
Your Honor, the trial judge was quoting a decision of the Supreme Judicial Court, which I suggest it's a different way of articulating that there's no potential danger to the community, the standard set forth in the Hodge decision. I suggest that it's really a semantic, perhaps, difference. And again, we've got an experienced trial judge, an experienced single justice. The Supreme Judicial Court has used that language in their decision. This court has used that language. I found it in a decision as recently as February of 2020. And I suggest that it's really a different way of saying the same thing, assessing the potential risk to the community.
So he also says, the judge, that because the defendant operated covertly and acted through seduction rather than physical force, I judge conventional restrictions inadequate in protecting against risk. Is that the appropriate standard?
Well, the defense did offer a bunch of suggestions as to what could be done to ameliorate any potential risk. And one of the things the defense offered was, if there was some probable cause, a search warrant could be obtained to examine his devices. And I suggest that that would be something the judge could find really wouldn't be workable here, because the defendant's text messages were recovered from the victim's devices, not the defendant's. And again, something after the fact would find a crime in the midst of it or after it had been committed, not not be it preventing it from even happening in the first place. So I suggest that that remark by the judge was a fair assessment of what the evidence had been in this case. And Your Honors, I would again suggest there's no abuse of discretion here, and that this court should not disturb the ruling of Justice Sachs here. And again, I know in the reply brief there was the COVID issues raised, but I believe those have all been addressed by the other panel that decided that particular appeal. And if there were no further questions, I would rest on my brief and ask this court to affirm the finding of the single justice.
Counsel, do you agree with your brother that we're not bound in any way by 20P 601, except maybe on the COVID stuff?
Your Honors, it's an interesting question. I mean, I would think certainly it's entitled to deference. Another panel has reviewed the record in this case. That case sort of leapfrogged this one in terms of being decided because this case was briefed. The defense brief and the Commonwealth's brief were filed. The defense filed the reply brief, and then the COVID pandemic resulted in the Christie decision and things allowing for reconsideration. So it's not entirely clear, but I would suggest that this court would reach the same conclusion as was reached in that case. Certainly that panel, I would suggest, to the extent the analysis would be abuse of discretion, that panel didn't abuse its discretion or commit an error of law when it reviewed Justice Wolahogian's decision as a single justice. If there were no further questions, I would rest on my brief.
Hearing none, Attorney Cusick, thank you very much.
Thank you, Your Honors.
Both. Very well done. The matter stands submitted.
The case is now being live streamed.
Okay.
Good morning.
Good morning.
Good
morning. This is the matter of 19P0926, Gary D. Lingley versus Raymond K. Hoyland and others. I'm Justice Desmond. With me is Justice Ditkoff and Justice Singh. We'll be your panel this morning. Be advised that we've read your papers and are familiar with the record, so you need not recite those things for our benefit unless there's something pertinent that you'd like to argue or bring to our attention. With that, Attorney Desolette, you have the floor, sir.
Yes, thank you, Your Honors. Lawrence Desolette representing the defendants, Raymond Hoyland, Technical Arts Sciences, and the Software Works Corporation. This is an appeal, Your Honors, from a jury verdict judgment after approximately 2 to 2.5 week trial. We allege that there were certain factors that the jury did not take consideration, and also we allege that there were some errors in the trial judge's denial of the defendant's motions for judgment notwithstanding the verdict. There are several issues that were raised by the brief that was originally filed by Mr. Aaron. For the most part, I'm going to rely upon Mr. Aaron's brief as to the issue of damages. Just briefly to state our position is that apparently I guess there is some confusion as to whether the benefit of a bargain rule applies or does not apply in Massachusetts. I guess the latest it does not, but the court should be looking to see what can best compensate a plaintiff who has been harmed. We believe that the jury did not take into consideration the mortgages that were on the property at the time. We also believe that certain factors were not considered, such as in particular, the own expert of the put on the stand by the plaintiff estimated that this was 2008, the year of the so-called too big to fail, where the real estate market crashed considerably during that time period and thereafter. In addition, the record will show that the plaintiff indicated in his testimony that he would have been able to afford to maintain the property even if the rents were lesser than, as he claims, my client, Mr. Hoyland, represented to him. But that's our issue on damages. Two major things, one of which is, did the plaintiff, Mr. Lingley, rely upon Mr. Hoyland's representations, which he claims were fraudulent, to enter into the purchase and sale agreement, which, by the way, as Mr. Aaron pointed out in his brief, indicated there were no warranties or representations made to Mr. Lingley as a result of the sale of the property. And we would submit based upon that he didn't have a claim to begin with. But putting that aside, Mr. Lingley testified, and Your Honors are all familiar with the record, that in fact he did not rely on anything that Mr. Hoyland said, but rather because of a seminar he took in which he was taught that he should always rely upon the bank's lawyer and not hire his own lawyer, he relied upon bank representatives and the bank's attorney at the closing for his.
They also relied. Didn't they also rely on those? Sorry, didn't they also rely on those same representations?
Well, the bank apparently relied upon Mr. Hoyland's representations. However, the bank officials testified basically they did not read the releases. Example, one of the leases had an automatic ability of one of the tenants to cancel within 1 year with notice. The bank official testified at trial that had he read that and known that, he would not have approved the loan. So I'm not sure that the bank read any of the releases or not. We do know that the leases were available, alleged forgery leases were available at the closing, which Mr. Lingley chose not to read, and apparently chose not to read much of anything prior to entering into the closing. But the key here is a couple of things, one of which is there was a release signed on December 2nd, 2008, in which is part of the appendix to my reply brief as well as Mr. Aaron's brief, which, among other things, released any and all activity by Mr. Hoyland prior to December 2nd, 2008. So the key would be, as far as I'm concerned, what did Mr. Lingley know and what should he have known based upon what he had before him at the time he signed that release?
What was the consideration for that release?
Well, first of all, the lease was under seal, so my position would be there need not be consideration. But the consideration, if you want to argue there was one, it was a promissory note in which, under the terms, Mr. Hoyland was to lend Mr. Lingley up to $50,000, not $50,000, but up to $50,000. My position being, once he lent him $1, he satisfied the terms of that because that note says any loans must be by agreement of the parties. In fact, approximately $15,000 was loaned to Mr. Lingley. No more loans were forthcoming, but given the terms of the promissory note, my client had no obligation to lend him more than $1 if he read the wording. The release released all claims, again, from anything that Mr. Lingley had known prior to that.
If that's true, doesn't that just drop you back into fraud? Your client saying, I'm going to lend you $50,000, which I promised to do long before, and he's actually giving a document that says, I'm only going to give you $1. Isn't that just fraud again?
Well, I'm not saying that that's what he said, Your Honor. What I'm saying is, if you read the document itself, the promissory note, it says lend up to $50,000 by mutual agreement, means both parties have to do it. So Mr. Lingley read it. He testified at trial, he read it, and he understood it, although he claims he didn't realize he was releasing Mr. Hoyland from any and all activity prior to that date. Although I got to add, my very able brother, Mr. St. Andre, was able to have Mr. Lingley identify about 60 exhibits rapid fire during the trial, prior to which Mr. Lingley claimed he had a lot of trouble reading and understanding things.
So the agreement was, I'll loan you up to $50,000 to do the repairs. Mr. Lingley says, okay, I'm doing the repairs. I need the money. He says, well, I'm not going to give you any of the money until you sign this release. And then he says, well, I set up to $50,000, but it had to be mutual, and I don't want to go up to $50,000, so I'm not going to loan you any more money.
I can only get by with the terms of the note says, Your Honor, and the note says up to $50,000, and that all of that has to be by mutual agreement. So I don't think there's any breach of the agreement if In fact, and I only use that $1 as an example, but he did lend him $15,000. And there's no evidence on the record that Mr. Hoyland himself ever denied any more money to Mr. Lingley. Mr. Lingley just testified that Mr. Hoyland went to Florida and didn't hear from him about that.
Well, he said,
But
see my lawyer.
I'm sorry, Judge Singh.
I mean, he said,
Yep.
go talk to my lawyer about it, right?
I believe that's what the record says. And of course, his lawyer couldn't release any funds otherwise. But
But now you're
again,
gonna
it's a
dismiss
time.
him from his lawyer? That's
Excuse
not
me,
me,
Your Honor?
that's my lawyer?
Well, he went to talk to his lawyer. I guess on 2 occasions, the lawyer did give him a check. But there's no requirement that he had to give him the $50,000 by the very terms of the contract. The other important thing here, and I
So
think
hold
the
on,
thing
before we move to the other important thing. So it almost sounds as if, and this is what Mr. Lingley seems to assert, that he was duped based on that language. And Mr. Hoyland seems to make a lot of the relationship between the two men, that they had known each other for a long time, that he had attended his son's wedding, that they had been to family gatherings. Are we not to consider any of that in the context of these negotiations?
Well, my client, Mr. Hoyland, denies that they had any kind of friendly relationship. They may have been at a wedding together. They didn't socialize together. They hadn't seen each other for a long time prior to this. They weren't best of friends, let's put it that way. They were perhaps social acquaintances. But the bottom line is, if you know, Mr. Lingley conveniently claims that because of a car accident, he's not able to understand anything. In the meantime, he had amassed an estate worth $2.5 million in various real estates and businesses, was able to identify 60 exhibits rapid fire, but claims he couldn't understand a 1-paragraph release when he signed it. And I suggest perhaps that's a little bit overreaching on his part. But the one other important thing that I was going to get to, and I think more importantly, is that the whole case, as Your Honors quickly have determined, rests on the issue of fraud. The trial judge refused to allow Mr. Aaron, over objection, to cross-examine Mr. Lingley on a verified complaint. The verified complaint at one point lists 14 different items that Mr. Lingley claims the evidences of fraud that he was not aware of at the time he signed the release. By not allowing, or by refusing to allow defendant's counsel to cross-examine Mr. Lingley about those 14 different evidences or claims of fraud and when they occurred and when he knew about them, pretty much foreclosed any possibility of impeaching the credibility of Mr. Lingley, because, you know, quite frankly, I don't see the difference between a verified complaint and affidavit. And I say that was the crux of the whole case. Mr. Aaron was prevented from examining Mr. Lingley as to when he knew about all those 14 incidents of evidence of fraud.
You're saying that you should have been allowed to elicit from the plaintiff all this other fraud?
Well, the plaintiff in his verified complaint lists A through N, which I counted to be 14 different alleged instances of fraud by my client on him prior to signing the release on December 2nd in 2008. What I'm saying is Mr. Aaron should have been allowed to cross-examine Mr. Lingley as to each of those evidences of fraud in depth, and also as to when he found out about them. Because if he found out about them prior to the signing of the release, then the law is, in my estimation, that the release is valid and releases Mr. Hoyland from all 14 of those issues of fraud. But Mr. Aaron was not allowed to cross-examine the plaintiff on all of those issues.
Say that he knew of these things before the release was signed?
Excuse me, Your Honor?
Did the verified complaint say he knew about this fraud before the release was signed?
No, he's claiming that there were 14 instances of fraud by my client that he did not know about before the release was signed. What I'm saying is Mr. Aaron was denied the ability to cross-examine him as to what those instances of fraud were exactly in detail, and secondarily, when in fact he did find out about them. It's not clear in the record when Mr. Lingley actually obtained copies of the final so-called forged releases. The evidence is not clear. At some point, he just said in his testimony that at some point the bank mailed him the leases. We don't know when he received them. There's no evidence in the record. So I think it's crucial that we find out, number one, are these 14 statements by him of alleged fraud really fraud? And number two, more importantly, when did he find out about those things? My position is if he found out about those things prior to December 2nd, 2008, then clearly they were released by signing the release dated on that day.
So
And again,
you're talking about the forged leases that it seems as though he found the originals in the file box once he took over the third floor office space?
He found a number of a box of leases, but I won't speak for Mr. St. Andrew, but my understanding, Mr. St. Andrew's position is the leases that are the culprit of the situation were the leases that were emailed, or I'm sorry, faxed to the bank's attorney or to the bank just prior to the closing, which was on September 23rd, 2008. The question is, when did Mr. Lingley see those releases? At some point he testified that he did, but he didn't give us a time frame. My position is if he saw those releases prior to signing what he claims were forged releases, but still signed the release, then the release is a valid release of all claims against Mr. Hoyland. But given the fact that he was not allowed to cross-examine on the verified complaint, which I think is pretty automatic, he should be able to. It's no different than an affidavit.
Established that he knew about the forgery before the release.
Excuse me, I didn't hear that.
You keep saying that if you could cross on the complaint, he would have revealed that he knew about the forgeries before the release. But how is that?
I don't know whether that's the case or not. Lots of things come out of cross-examinations that you don't know about until you do it. What I'm saying is, I think it's black letter law that you should be entitled to cross-examine a plaintiff on a verified complaint. It's no different than an affidavit. I don't know what each of those 14 alleged evidences of fraud Lingley would have said about, and I don't know what he would have said as to when he found out about them, or did we have evidence to contradict when he said that he found out about them? We'll never know because he never got to do it.
You can cross on a verified complaint that's not the subject at bar, right?
Excuse me, Your Honor?
The verified complaint that you can cross on can't be related to the matter that's at trial in Massachusetts. Isn't that correct?
As I understand it, the court looks at a verified complaint no different than an affidavit. I mean, as I say in my brief, how is it you can cross-examine a plaintiff under oath at a deposition, under oath in an affidavit, but not under oath in a verified complaint? He's making all of these allegations. He's attesting under oath that, in fact, this is true. So why should not the defendant have an opportunity to cross-examine about what's in the complaint? And that it's the fraud is, and when he found out about it, is the heart of the case.
Counsel, you referenced the importance of the cross-examination were these 14 allegations. Are you saying that there was no other way to get into those 14 allegations during the entire case? They never came up? There was no other way to get at that?
I'm sure some of them came up, Your Honor, but what I'm saying is, cross-examination, at least in my experience, you're focusing on a certain particular item for a period of time, as opposed to haphazardly. Here he lists, for dramatic purposes, apparently 14 alleged instances of fraud that he did not know about. All I'm saying is the defendant should have had the opportunity to cross-examine him as to when he found out about those. I mean, it's not the key to the case. If he knew about all of those, if in fact they're true, prior to the signing of the release, then the release is valid for all claims against the defendant. But he was denied the ability to do that.
Thank you, sir. I see that's your time. Let me just ask, any other questions from the panel? Hearing none, thank you, Attorney Desolette. Attorney St.
Thank you, Your Honor.
Good morning, Your Honor, and I'll try to be as brief as I can. A couple of points that Mr. Desolette's raised. During the course of the trial, the defense attorney, Alan Aaron, wanted to cross-examine Mr. Lingley regarding the verified complaint. And at that time, there was confusion as to whether Mr. Lingley had ever read the complaint. It looked as though he didn't, but Judge Billings was concerned that this was going to be a very confusing part of the trial. And at no point did Mr. Aaron make an offer of proof as to what was in that verified complaint he wanted to cross-examine Mr. Lingley on. Had he done that, then it might have turned out differently, but there was never any indication from Mr. Aaron that there was anything that was relevant in the verified complaint that he ought to be able to cross-examine Mr. Lingley on. Secondly, Mr. Aaron was never denied the opportunity to cross-examine Mr. Lingley regarding the facts that were alleged in the verified complaint. There were allegations of fraud that were included in the complaint because we had to show that there was something behind the allegations we were making. But if Mr. Aaron wanted to show that Mr. Lingley was aware of the fraud beforehand, he was never denied the opportunity to do that. In fact, he had plenty of opportunity to do that, and it had nothing to do with the verified complaint. So the second thing is that I believe that Mr. Desmond said that there was nothing in the record that showed that Mr. Lingley, when he received or when he was aware of the forged.
Did you mean Justice Desmond?
I'm sorry. I'm sorry. No, I didn't mean Justice Desmond. I meant Mr. Desilets. I'm sorry. Mr. Desilets said that there was nothing in the record showing when Mr. Lingley was aware of the forged leases and leases extensions. Well, that's not correct. The record showed that Mr. Lingley found them after the passing and after he had been told by one of the tenants that the tenant was not returning. Mr. Lingley then went into the file box, showed the tenant, and I believe this was sometime in January or February, the lease that was supposedly signed by the second floor tenant. And that's when the tenant said, "That's not my name on that lease." That's when Mr. Lingley became aware that there was fraud afoot here. So it was well after the closing, well after the signing of that release. Mr. Desilets made a point saying that Mr. Lingley testified that he relied only on the bank and that he never relied on anything that Mr. Hoyland told him. Well, that's not true. The record shows that Mr. Lingley relied on Hoyland from the get-go. So did the bank. So did Randolph Savings Bank. So did the mortgage broker that Mr. Lingley hired. So did the bank's loan committee, and so did the bank's appraiser. So if you look at the sentence that Mr. Aaron quotes in his brief, you can see that it's taken out of context. Mr. Lingley was testifying that he relied on the bank to verify the releases, but he never said he didn't rely on Mr. Hoyland's representations regarding the rents or anything like that. So they're kind of grasping at straws here. Another point that I think needs to be made is that this was a case that was tried almost 3 weeks to a jury. There were smoking gun exhibits that they saw. They were able to look at Mr. Lingley. They were able to look at Mr. Hoyland and make assessments of the credibility of both, as did Judge Billings. And I've seen nothing that is contained in any of the defendant's briefs or anything that Mr. Desilets said that should upset that. The other thing that needs to be mentioned is that there was a remittitor order here. And that remittitor order came as a result of Judge Billings' careful determination that perhaps the damages awarded by the jury were too big and he cut them down substantially. And in my brief, you'll see how I explain that based on the evidence, an award of damages, single damages of 1.3 million was probably less than what Mr. Lingley approved at trial. And that begins on, I think it's page 46 of my brief, but I spell out that the damages.
Can we talk for a minute or two about how Judge Billings got to the damages because I may not be understanding it correctly. It seemed like he added in some things, but he started by taking the value of the properties or the value they should have had and subtracted what the foreclosure sale was for all 3 properties.
Right,
And then he added a bunch of other things.
right.
And what I don't get about that is, considering that the deficiency of the bank was eventually forgiven, shouldn't he have taken the equity your client had in those 3 properties and subtracted whatever cash he got back out? He got no cash back out at all. It all went to the bank. Wouldn't that have been the right number to start with? Then you add the other things. What am I missing?
Well, the deficiency wasn't done away with. The deficiency, in fact, still exists. Mr. Lingley made an agreement with the bank that out of any recovery that he's going to get, or could get in this case, the Randolph Savings Bank would receive, I think, 25% of that. So the debt wasn't discharged. He has to pay the bank back. And if, in fact, he is allowed to keep his judgment with the 93A award, the bank is going to receive more than they would have received from that $800,000 judgment. So it's not just a simple matter of that, because that the deficiency was not discharged. And probably Mr. Lingley is going to pay back the bank more than the actual deficiency was because of the agreement that he entered into. And the other thing, too, is that, yes, there was a declining market, but that was a temporary market. Look at what happened since then. So a court can't really factor in what effect the loss in price had to do with the market, other than the fact that the Lingley lost the properties not because of the decline in the market, but because of the foreclosure caused by Hoyland. Judge Billings cites cases that talk about, and I think FEMARK is one of them, that talk about if there is a declining market, that really shouldn't fall on the plaintiff. If it in fact exacerbates his damages, that really falls on the defendant. So other than that, Judge, I don't think everything I need to say is in my brief. Thank you.
Thank you. Thank you both very much. Matter stands submitted.
Thank you, Your Honors.
The case is now being live streamed.
Thank you. Good afternoon, Attorney Harrington and Attorney Moran. I'm Justice Desmond. With me is Justice Ditkoff and Justice Singh will be your panel this afternoon. This is the 5th case on our list, docket 2019 P1102, Dean Intonti and others versus Albert Intonti. We've read your papers. We're familiar with your arguments in the record. Please take your time to get right to the heart of your argument. Attorney Moran.
Thank you, Your Honors. May it please the court. As stated, I am Philip D. Moran and I represent the appellant Albert J. Intonti. May I begin by stating that the trial court, I submit, attempted to play Solomon and decided to split the decision in 2 in an attempt to satisfy everyone. It is our position that its reasoning in finding the July 22nd, 2010 amendment valid under the Ferry et al. Case and numerous other cases cited in our brief should apply equally to the Clara Intonti's beneficial certificate, allocating the Wheeler Street property to her son, the appellant, under at least 3 provisions of the irrevocable trust, namely paragraphs 3.5, 3.7, and 7.11.
Counselor, how do we know from this record that you raised these arguments below?
From the record, Your Honor, I was not trial counsel, so I'm not sure how whether these were raised or not.
Well, if they weren't raised below, how can we grant you relief?
I believe that the argument, Your Honor, would be that based on Judge Moriarty's decision, that whether they were raised below or not, her finding was clearly erroneous, and that I should be allowed as appellate counsel to raise these issues.
Continue.
May I proceed?
Please continue.
Under 3.5, Clara had the power to appoint any or all of the principal of the irrevocable trust to any one of the legatees by written memorandum delivered to the trustee. Under 3.7, Clara had the right to disclaim, release, or renounce any interest in total or as to a particular asset. Under 7.11, a distribution may be made by the trustee by execution of a certificate crediting or allocating specific property to a beneficiary. And that's exactly what Clara Intonti did. She created a written memorandum or a certificate transferring under any one or all of the above powers the real property located at 7 Wheeler Street in Peabody to her son, to the exclusion of the other legatees, her grandchildren, who are the appellees in this matter. As stated in Ferry, which, as I pointed out above, was the court's reasoning for the July 22, 2010 amendment valid, when interpreting trust language, the court has stated, "We do not read words in isolation and out of context. Rather, we strive to discern the settlor's intent from the trust instrument as a whole and from circumstances known to the settlor at the time the instrument was executed." Clara knew the appellant and his wife were getting divorced, and her intent was clearly to favor her son over her grandchildren. The manifestation of her intent may also be established by other evidence admissible in a judicial proceeding. Her handwritten notes, as well as her attorney's notes, were introduced into evidence, clearly indicating what Clara's intent was. It is fundamental that a trust instrument must be construed to give effect to her intent in light of the circumstances known to her at the time she created this beneficial certificate. And strict compliance, I would submit, is not always required. Yet this is what the court used as its reasoning to split the decision. Under Kirschbaum versus Winnett, a 2004 case of this court, it was held that in this case, where the settlor had a clear intent to amend the irrevocable trust and the trustee was present, and a third party, her attorney, held the document, the amendment was deposited in conformity with the trust provisions. Here it is our position that no amendment of the realty trust occurred as the beneficial interest passed through powers set forth in the irrevocable trust. It was simply a valid inter vivos transfer of a future interest. The title holding entity was left undisturbed. Paragraph 3.5 reserves its powers to appoint any or all of the principals of the trust to any one or more of the legatees during life by a written memorandum. The June 13th, 2010 beneficiary certificate is exactly that. It is a written memorandum. Thus, I submit it as a valid and binding exercise of the powers reserved in the irrevocable trust, and it is binding on the legatees. No amendment to the realty trust was required, I submit, to exercise the power of appointment reserved by her in the irrevocable trust. As between parties to the irrevocable trust, recording at the registry of deeds is permissive, but the lack of recording does not invalidate her intention to finalize her estate plan. Had she recorded it, that would have been conclusive evidence, and we wouldn't be here today arguing the matter. But she chose to retain the certificate and shared it with her attorney and her son, the appellant. Note that Clara's handwritten notes state, and I quote, "On June 13th, 2010, I changed the beneficiary to you. Therefore, you are now the sole owner of the house when I pass away." She also told her attorney, "No change in the tax bill and Al is the beneficiary. Also, she told her attorney that she was praying for an uncontested divorce. These notes admitted into evidence clearly reflect her intention with respect to the disposition of her property when she passed away.
Counselor, if Albert was the sole beneficiary of the nominee realty trust, then isn't that inconsistent with saying it's yours once I die? Wouldn't that have meant it's yours right now?
Well, that's one of my points, Your Honor, that this was not a transfer of a property at that time. It was transfer of a future interest in the property, and it didn't occur until she passes away. Because otherwise, if she had transferred the property to him on June 13th, 2010, then he would have, the tax bill would have gone to him and he would have been the proper owner of the property. But she clearly stated that he was not the owner of the property at that time. It would only be when she passed away. Anyway, Your Honor, these notes admitted into evidence, as I said, clearly reflect her intention with respect to the disposition of her property when she passed away. This is, as I said, was clear. It was not an inter vivos transfer of property. It was simply a revised contingent interest in property that would fully vest in Albert when she passed away. As it was, as I again said, an inter vivos transfer of a future interest. If she had amended, as I just said, then Albert would have been the owner of the property on June 13th and the tax bills would have gone to him. But she clearly states in her notes that he owned the property not then, but only when she passed away. Again, she utilized the power under paragraph 711 to distribute 100% of a specific property, namely the 7 Wheeler Street PB, by virtue of the certificate signed by her as trustee. Excuse me. Numerous courts, including this court, have held that a trust instrument may be reformed to conform to the settler's intent.
Now you've lost me again, because if she distributed the house to Albert, then it would have been Albert's at that point.
That's correct. It would have been, but
You
it
said it
wasn't.
was not Albert's. It belonged to mother or to the trust until she died.
That's correct.
Well, it can't be both. Either it's Albert's as soon as she distributes it, or she didn't distribute it to him until she died.
She didn't distribute it to him. She distributed a future interest. The certificate is a beneficial interest. It's a future interest, and it didn't occur, wouldn't occur until she died.
Okay.
As I started to say, numerous courts, including this court, have held that a trust instrument may be reformed to conform to the settler's intent. There is no doubt whatsoever as to Clara's intent. The trial court should have reformed the instrument to conform to her well-evidenced intention to favor her son over her grandchildren. As stated in Scott in trusts, under the parole evidence rule, if the manifestation of the settler is integrated in a writing, and if the writing is adopted as it was here by Clara, it would be the complete expression of her intention, and extrinsic evidence would not be admissible to contradict that written instrument. I submit if Clara made a mistake by not recording the certificate, that's simply what it was. It was a mistake, and a mistake that equity should resolve. Excuse me.
So the intent, you're saying the intent trumps specific requirement, not a general requirement of recording, but it was part of the document that it was a requirement that any amendments be recorded. So do we look to intent at that point, once that requirement has not been fulfilled?
It's our position, it wasn't an amendment. It's simply a transfer, is a certificate transferring a future interest, and then as between parties, recording would be permissive, but not mandatory.
Between all parties? Even the
No,
legacy?
Just would be permissive among all parties. And
With
in
notice?
this case, excuse me?
With notice?
The notice was given to Albert because he signed the certificate as well as his mother. So he certainly had notice of the transfer of the 100% interest in that property.
Gather you don't know whether a request for reformation was made at trial?
I don't know what, sir.
I gather you don't know whether there was a request for reformation made at trial. Is that
I
correct?
don't know that. I don't know that.
Okay.
But if there was a mistake, I believe equity should resolve it through reformation. And the court should have reformed her mistake to conform to her intentions. And therefore, I submit the trial court was plainly wrong and the decision was clearly erroneous with respect to judgment number 1. And that number 1 stated that the Clara G. INTONTI Irrevocable Trust is the 100% beneficiary of the 7 Wheeler Street Trust. And it is our position that this court should reverse and remand the matter to the trial court with the direction that Albert J. INTONTI is to be adjudged the 100% beneficiary of the Wheeler Street Realty Trust, and further adjudge that the proceeds of the sale of the property are his sole and separate property. Thank you.
Thank you. Bear with me 1 second. Attorney Harrington.
Good afternoon.
Good afternoon.
Good afternoon, Your Honors. Mary Harrington, representing the appellees in this matter. I first want to address one of the questions this court raised at the outset of the argument about whether or not certain issues were raised below. I pointed out in my brief that in fact, these arguments were not raised below and that Mr. INTONTI had a completely different position at the time of the trial, suggesting that the document he now says was signed on June 13th, 2010, was in fact signed on June 13th, 2000. And I pointed out the affidavit he provided. I pointed out certain other evidence that came in and exhibits that show that. But more importantly, perhaps, on pages 48 of the supplemental appendix and 50 of the supplemental appendix, both of which are Mr. INTONTI's trial proposed findings and rulings, you will find that on page 48, he did rely upon the terms of the realty trust in talking about whether or not the certificate in this case was valid and appropriate, the one that he wants it to be. And yet on page 50, when he is talking about the change in the percentage of beneficiaries under the irrevocable trust, he relies on the irrevocable trust language. So you made a completely different argument, acknowledged below that it was the language of the realty trust that controls the issue before this court, and it was the irrevocable trust language that controlled the other percentage change that Mrs. INTONTI made that's not before this court.
Let me ask you this, Attorney Harrington, picking up on Justice Ditkoff's question. Do you believe that we have sufficient record to resolve these issues?
No, because I think you would, well, I think on the record you have, you cannot resolve any factual issues, and it would have to be purely on the law. No record was provided to you to know. Mr. Moran argues intent and what Clara's intent was. That's purely a factual finding. You don't have the testimony of the witnesses before you. You didn't see the witnesses who testified. You don't know what all of the evidence was. And without that, you cannot get to what her intent was or was not. The trial judge had all of the evidence before her, heard and saw the witnesses, and obviously ignored certain evidence that Mr. Moran wants you to rely upon, but she had a lot more evidence that you don't have before you. So I don't think that you can get to the intent issue and make a determination different from what the trial court made. I do believe you have enough record to affirm the trial judge, which is on the law, and that's what I think you should do. For Mr. Intonti to have a chance to prevail in this matter at all, the terms of the irrevocable trust must be what control and determine whether or not the document he wants you to enforce is valid. He nowhere suggests, even during this argument, that if the terms of the realty trust control, that he even has the basis for any argument to be before this court.
There's something I don't get, Counselor. Why is changing the beneficiaries of the realty trust an amendment of the trust? It's not part of the trust to start with.
Well, because it's the only way you could, in this particular case, change the beneficiaries is by an amendment. But if you look at the Roberts case, and it's interesting, Mr. Moran cited that in his reply brief. I have relied upon it in my main brief. That case was a nominee trust. It had the same requirements for recording amendments that this particular case has. Apologize. The trust provided that third parties could conclusively rely on a trustee's certificate and on the execution of any document by the trustees. The beneficiaries could add or remove a trustee and amend the trust. Such actions were required to be recorded in the Registry of Deeds. There were two amendments made in that trust. One was the change of a trustee, but the other was a gift over of an inter vivos transfer of a future interest. And the court found that that was an amendment and that in fact it needed to be recorded. And the court says on page 692, the first and second amendments, which effectuated the gift over, were embodied in formal documents which were notarized and thus had an attesting witness and recorded. The formalities ensured that the gift over was carefully and seriously made, and the notarization and recording of the amendatory documents provided reliable evidence of the disposition.
Sorry, Counselor, is this Roberts? Which case is this?
Roberts versus Roberts, and it is at.
No, I just want to make sure I was on the right case.
And in footnote 3, the court notes, we note that in the present case, while the beneficiaries had a great deal of control, their power was not unlimited. And they list some limitations, including they could not revoke or modify the trust except by formal written instrument. So we have the exact same situation here. And interestingly, Attorney Moran has used the same language, a gift over of a future interest. And that's what happened in that case. And it was required to be recorded. It also suggests to this court that the document that Mr. Intonti relies on is not even a trustee certificate, and it within itself is contradictory. It says the undersigned beneficiaries are the beneficiaries, and the undersigned are the trustees of the irrevocable trust. No, Albert Intonti doesn't sign it as the beneficiary. It's also not a trustee certificate. It wasn't signed by the trustees of the realty trust. So I'm not even sure that the document itself does what Mr. Intonti is arguing to this court that it did, that it changed anything. It is a statement that's not properly done. Forget that it wasn't properly recorded. And it's inconsistent on its face. So unless the court has additional questions, we ask you to affirm the judgment below. We think the court was absolutely correct in her finding that the requirements were just not met. I do have other arguments in my brief. I will leave those to the written brief and not address them again.
Attorney Harrington, Attorney Moran, thank you both very kindly. Your matter stands submitted.
Thank you.
Thank you.
The case is now being live streamed.
Good afternoon, Council. This is the sixth matter on our docket today. It is John Doe number 3142 versus the Sex Offender Registry Board, docket 19P0947. We have indeed read your papers, are familiar with your arguments, so you need not expend much of your time going over those things, but you can get right to the heart of your argument should you so choose. That being said, Attorney Hernandez, you have the floor.
Hello, Attorney Hernandez for the plaintiff, appellant John Doe. I would like to apologize in advance for my voice. I'm recovering from a sickness I just found out is actually strep throat, so I'll try my best so that you could hear me. As you know, my client was classified as a level 3 sex offender for acts he committed in 1982 and 2001. I'm here today requesting that this court lower my client's classification level from a level 3 to a level 1. First, the hearing examiner committed 2 errors in applying the regulatory factors. The hearing examiner erroneously applied risk elevating factor 21, which is diverse victim type, because the first victim was 14 years old and the second victim was 32 years old.
So
However,
why doesn't that apply? At both times, John Doe was an adult. And so whether it occurred when he was 19 and the victim was 14, or whether it occurred when he was 27 or what, I forget exactly what his age was at that point, 27, I want to say, and the victim was 32, isn't that technically accurate?
well, what I would argue is that the hearing examiner had discretion to decide how much weight to give this risk elevating factor. And I would argue that he should have given it lower risk elevating weight because of the particular circumstances of this case. As you indicated, my client was 19 years old when he committed his first sex offense, and the victim was 14 years old, only a 5-year difference. When he committed the second offense in 2001, my client was 37 years old, and the victim was 32 years old, a 7-year difference. So the difference in ages between my client and the victims at both particular times was less than 7 years old. So I think that's something that the hearing examiner should have taken into account, because it's very different than.
This factor doesn't deal with age discrepancy, right? It's
No
not geared toward looking at age discrepancy. It's geared at looking at the type. Is the person a predator towards children or adults? And that was taken into consideration.
Well, I would assert that the hearing examiner should have looked at the individualized circumstances of this case. And there is a big difference between a 50-year-old sexually assaulting a 14-year-old and a 19-year-old sexually assaulting a 14-year-old. Although technically they're both adults, there is a huge difference between a 19-year-old and a 50-year-old. So that's what I would assert to you, that the hearing examiner should have given this risk elevating factor less weight because of that. And also the hearing examiner erroneously applied risk elevating factor 16, which is a public place, because the Doe committed one sex offense in the woods. And I would assert that there's not sufficient information in the record regarding the circumstances of where the woods were located. Also, there's no information on the day of the week or even the time of day. I would assert that my client made an effort to conceal his behavior by committing it in the woods. So he did have an expectation of privacy. And because of that reason, I would assert that the hearing examiner, again, should have applied less risk mitigating weight to this particular factor.
What reasonable expectation of privacy do you have in a public area, woods, that was located near a business office or business park?
Yeah, we don't know how far away from the business it was. It's the only thing that says that it was near a gravel business. Again, I don't know what that means. Near could mean 3 miles. It could mean a couple of yards. I'd have no idea what that means. And I know in the record, the victim actually even said that both times it was in his house. But my client did admit that one of the times it was in the woods. And woods are different. There's some woods that are
there's like nobody around at all. And there, you know, the expectation of getting caught is minimal. And then there's some woods that, you know, within, like where I live, within a couple minutes, you know, somebody could easily walk by. So I would assert that under these circumstances, not knowing enough regarding where the woods were located or the time of day or even the day of the week that it happened, that so the hearing examiner should have given this factor less risk elevating weight. And if you'll see, there's many positive aspects that are present in this case. And these are the reasons why I would assert that my client should have been classified as a level 1 sex offender. His last offense was almost 2 decades ago when he was relatively young. He was 37 years old.
Need we take into account that he's been incarcerated the entire time?
So he has been, and I believe it or not, I've had clients that continue to assault even while they're incarcerated. So I would assert the fact that there's no indication that he has sexually assaulted against anybody while incarcerated is something that should be taken into account. Again, it's been almost 2 decades.
What about his drawings while incarcerated?
Are we to consider those?
Well, that's obviously not right for him to do, and it was a violation of their rules, you know, within the institution he was in. But I would assert that's not sexual assault. I mean, obviously, it wasn't a good thing for him to do under these circumstances.
The nature of the drawings depicted nude women with some violence. Is that right?
I don't recall violence. I know there was a depiction of nude women. I know he was actually, you know, taken out of the sex offender treatment group that he was in because of that, and also he got a disciplinary report. So his time while he was incarcerated was not perfect, for sure, but I would still assert that he did not sexually assault while he was incarcerated. He got released in 2019, and he provided evidence to the hearing examiner that he would have the support of his family and community once he was released. He had the support of his mom and 4 siblings. Additionally, a priest wrote a letter of support on his behalf, indicating that he would be willing to continue to help him financially, just a little bit, but financially, and also to connect him with resources in the area and to provide emotional and spiritual support once he's released. Additionally, there was another letter of support by the director of the Boston Release Network, basically indicating the same thing, that he would be willing to provide my client with resources and to support him when he was released from incarceration, which again was in 2019. As you know, my client was a productive member of society to some extent when he was not incarcerated. He obtained his GED. He had a relatively strong work history. While he was incarcerated, he did work and he was involved in programs. He wasn't the perfect inmate, that's for sure, but he was involved in programs and he did work. He was in the military at some point and is eligible for veterans benefits as a result. He hasn't had any issues with drugs or alcohol since his last offense. And he was involved in drug and alcohol treatment while he was incarcerated and had planned to continue with that treatment once he was released in 2019. Lastly, I would request that this court remand the case back to the board for another hearing. As you know, the board failed to make a finding that public safety interest is served by the publication of my client's personal information. And if there's no further questions, I'll rest on my brief.
Thank you very much, Attorney Hernandez. Hearing none, we'll move to your sister. Would you pick up where your sister left off? There clearly is no findings with respect to public dissemination. What do you say?
Sure, and just to introduce myself, good afternoon, and may it please the court, Nicole Nixon, Assistant General Counsel on behalf of the board. And I do acknowledge that there is no public safety interest finding or the need for a public safety interest finding in the hearing examiner's decision. It was issued well before DO 496-501 came out of the SJC, which is the case which now requires a hearing examiner to make explicit their findings on each of the 3 prongs necessary to a classification decision. However, if you look at the court's decision in DO 496-501, which I'm sure you're all well aware of at this point, they stated that a remand may not be necessary in certain circumstances. And I would suggest that this is specifically the case where a remand wouldn't be necessary, because the facts of this case clearly dictate the appropriateness of the level 3 classification. If you look at the facts of this case, the governing sex offense was perpetrated against a female neighbor and involved an extreme amount of force and violence. That sex offense was committed after he had already been previously convicted of a sex offense. So that shows that he was undeterred from his sex offense conviction and ended up sexually reoffending, which is important in the analysis. He's also offended against both child and adult victims. And in addition to his governing sex offense history, he also has an extensive criminal history with multiple violations of probation and has incurred multiple disciplinary reports while incarcerated. Getting to the disciplinary reports, to answer Your Honor's question about the nature of the drawings, I would suggest that they were extremely violent in nature. If you look to the record appendix, it's RA2, I believe on page 110, it provides a description of the drawings that the petitioner had drawn while in prison and received disciplinary reports for, and which was an impetus to him getting suspended from sex offender treatment. I would suggest that the drawings were extremely violent in nature and actually were similar to what the victim had experienced in the governing sex offense. So I think that is important to your analysis as well. Also important to your analysis of whether a remand is necessary is the fact that he's done very poorly in sex offender treatment. In fact, he's been suspended twice, and he wasn't allowed back into sex offender treatment until 2022, which I believe was after his release date. So that shows that he hasn't progressed in prison or within treatment, nor has he learned all that much, I would respectfully say, from his sex offender treatment. So based on all these circumstances, an internet publication of his registry information would clearly serve a public interest here. I would say that if you look at the SJC's case in 496-501, they talk about where somebody poses a moderate risk of reoffense and a moderate degree of danger and has been convicted of a sexually violent offense. And in these circumstances, internet publication will almost invariably serve a public safety interest. I would suggest that's exactly the case here. He was convicted of a sexually violent offense, and he poses not only a moderate, but a high risk of reoffense as well as a high degree of danger. So there's certainly no reason to remand the case for further findings as to the public safety prong.
What do you say, Attorney? I'm sorry?
Oh, no, I'm sorry, go ahead.
What do you say, Attorney Nixon, with respect to this expectation of privacy in the public woods?
Sure, and I would say that the hearing examiner's finding as to the woods located near a sand and gravel company, that was properly within his discretion to find that area a public place that fits squarely within the regulatory definition of what's considered to be a public place, namely that it was open to the scrutiny of others. The evidence, the subsidiary evidence, in a classification hearing must be proved by a preponderance of or subsidiary findings must be proved by a preponderance of the evidence. That happened here.
Practically speaking, I mean, isn't he going to the woods to try to secrete the conduct? Isn't that the whole point in going to the woods?
Well, we're not really sure based on the record why they chose the woods as their location for sexual intercourse on that occasion. Even if that was the case where he was trying to conceal the activity by going into the woods, if you look at the regulatory factor, it didn't happen in this case. The hearing examiner didn't make this finding, but if you look at the regulatory language, if somebody makes an effort to conceal themselves, say by closing a door or something of that nature, less weight might be afforded under that factor, but the factor would still apply because it still falls within the definition of what's considered to be a public place under factor 16. Namely, there's no reasonable expectation of privacy in a public area such as woods, and it's open to the scrutiny of others. Anybody could have walked by at any moment.
By the way, I meant to say keep secret the conduct, not secret.
Yeah, I understood. And even if your honors do find that it was error to apply factor 16 in these circumstances, I would respectfully suggest that it's harmless error in these circumstances. If you look at the case as a whole, that's just one regulatory factor which increased his risk of reoffense. But if you take that out of the equation, there's still clear and convincing evidence to suggest that the offender poses a high risk of reoffense as well as a high degree of danger. And if there's no further questions on any of the other issues raised in my sister's brief and I addressed in my brief, then I would rest at this time.
Counselor, I should mention that I have repeatedly complained to your colleagues about trial transcripts not being included in the administrative record. So should do the opposite here and say how pleased I was to see that the trial transcript was included in the administrative record here.
I was as well, Your Honor. I wasn't with the board when this hearing happened, but I was very happy that we did have the trial transcript in this case.
Thank you.